name is Jeff Rakes. I'm the planning director at the city of Greensburg, and I'm also vice president of the Southwest section of the American Planning Association Pennsylvania chapter. We're happy everyone is here. I apologize for the technical difficulties. I'm going to turn it over to Alexis and Alan. They're going to do some introductions, and then we're going to move into some of the content. I know we've got an hour. We're going to try to, we didn't begin on time, but we're trying to redeem ourselves by ending on time. And with that, I'll go to either Alexis or Alan.
All right, thanks, Jeff. This is Alan Shuckrow. Nice to meet everybody. It doesn't look like the chat is enabled, at least not for me. So usually we say things like, if you have any questions at any time, put them in the chat or introduce yourself in the chat so we know where you're from. But I don't know that we can do that. Maybe when Jeff is fixing the other issue, maybe he can look at that too. But
Can do. Thanks, Alan.
Right. So I just wanted to give everybody a little bit of perspective as to why Alexis and I would be talking about this topic. We're just two lawyers here from Pittsburgh at our law firm, Strasburger McKenna. But when you have your career, sometimes you don't know where it's going to take you and what you're going to end up sort of being an expert in. And in 2017, Alexis was a law student and had just started at the firm as what we call summer associate in the legal field. And a friend of mine had called me, and these folks that he knew were they were wanting to be opposed to a proposed development that was was on the table out in Indiana Township, which you may know is sort of, if you're from the western part of the state, is near the Fox Chapel area. It's a really nice area, not super developed. Some development, but kind of rural still. And this was a proposed pretty dense townhome development on a nice undisturbed site. And so we got involved. We found out that it was supposed to be a planned residential development. And so we got involved in this case. And 6 years later, we're still involved. We have been up and down to the Commonwealth Court of Pennsylvania twice. We, on representing our clients, have actually won both times. These are now reported opinions that you can cite to and read. And we're going to talk about those a little bit. And the developer is back now with another revised version of this plan. And at the end of this presentation, we're going to show you what's happening currently. And along the way, as we talk about this case, we're going to talk about planned residential developments and what we've learned from a legal standpoint, and also, some the process that you go through, and maybe some pitfalls that you may or may not know. Planned residential developments are somewhat popular, at least in the western part of the state. Editorially, I think that what happens sometimes is that developers see a chance to have higher density, and that the municipalities are not always giving these plans the full scrutiny that they should, and we're gonna talk about that today. But what is a planned residential development? Just sort of the definition out of the statute, the municipalities planning code, which governs developments in Pennsylvania, which I'm sure you know, is an area of land to be developed as a single entity for a number of dwelling units or combination of residential and non-residential uses. And the plan does not correspond in lot size, bulk, type of dwelling or use, density or intensity, and lot coverage for the particular zoning district that the property is located in. But not every municipality has a planned residential development as a permitted use, or and if they don't, you can't have one. And the municipalities planning code does go into great detail in terms of what has to be in an ordinance for planned residential development. We're going to talk a little bit about that. Another way to look at it, one of the Commonwealth Court opinions that's talked about PRDs says that they're an alternative to traditional cookie cutter zoning, and that provides flexibility. And it's designed to offer the municipality and developers flexibility. The idea is to create a method of approving large developments which overrides the traditional zoning controls and permits flexibility. So that's what a PRD is. It also is supposed to encourage conservation and more efficient use of open space and greater opportunities for housing and recreation. And it's supposed to provide the flexibility with less red tape, less administration without undue delay. But there is a pretty meaty structure set up under the MPC for approvals, and it still can take time. So benefits and value of a PRD, again, on paper, and sometimes this plays out. For the developer, they can get higher density, flexibility, and potentially a streamlined process. For residents of a municipality, focus on open space and recreation. There should be a variety in the type and design of housing and an emphasis on efficient land development, and the natural resources are supposed to be preserved to a greater extent than a typical subdivision. And one of the key definitions in the municipality's planning code, which should carry forth into most or all of these ordinances, is something called common open space. And this becomes important, and we talk about the case that we had here. Common open space is a parcel or parcels of land or an area of water or combination of land and water within a development site that's designed and intended for the use or enjoyment of residents of the development, not including streets, off-street parking, areas set aside for public facilities. The key there is that a developer is not supposed to be able to just say, oh, well, there's all this land that's not going to have impervious surface. That's all open space, and that gets to count toward the open space. No, it's supposed to be specifically designed and intended for the use or enjoyment of the residents. And we'll talk about this a little bit later, but that's often overlooked, and developers just come in and with an open space calculation.
Great.
Alexis?
So yeah, and to just add on to that, there is a precedential Commonwealth Court case called Harvin. I think it's versus the Board of Commissioners of maybe I couldn't think, someplace out by Philadelphia, other state from us, across the state from us. So there's a published case that says, that these public facilities cannot be stormwater management facilities. Even if the stormwater management facilities are to be owned by an HOA and serving the residents of the plan, those are still considered public facilities under Pennsylvania law, and they cannot be included in the common open space calculation, which is a misunderstood principle. When, reviewing a lot of these PRD plans, people try to include those in their common open space calculation.
It's the Board of Commissioners of Upper Chichester Township, if I said that right, the Harvard case. There we go.
That's what I was thinking, and I knew I couldn't pronounce it after I started trying to say it. So what is the process for a PRD? Well, it's twofold. There's tentative development or approval, and then there's final development approval. So the tentative approval process is really a misnomer. This is the paramount review and consideration by the planning body and by the governing body of the municipality. The two-step process that the General Assembly created for these PRDs was intended to expedite a process that would otherwise require separate applications for, say, subdivision and land development, zoning approvals, or rezoning approvals, because of how vast these departures tend to be from the original zoning district. So that means that the PRD was intended to supersede Articles 5 and 6 of the Pennsylvania Municipalities Planning Code, which I think we all know is the state planning code for all municipalities across Pennsylvania.
Alexis,
The application.
Alexis, I just want to interject here. The whole thing about tentative approval being a misnomer, I think I wasn't obviously involved in drafting the legislation, and I wasn't there in the room, but this process was a developer friendly process, at least supposedly, and I almost believe that the word tentative was picked on purpose to throw people off the scent, so that they felt that they didn't really have to get involved if they were going to oppose one of these until later. But as we'll see, that's not correct. If you want to get involved in this process, either as the municipality giving it scrutiny or as a resident was standing in the community, you have to be paying attention at the tentative approval process, because once you get to final approval, you're too late.
That's very true. And, as Alan mentioned kind of off the top, this process was, I think, originally intended to be quicker, smoother, more efficient, easier than going through the SALDO zoning, rezoning processes that would otherwise be required to impose a development like this. But in practice, it is, I don't think any smoother, any easier, any quicker than those other processes would be. And honestly, the way that some of the ordinances that we've come across have been written, it does make it more difficult, a little bit more ambiguous to get these sorts of developments in and approved. But it is, I think, intended to be a developer-friendly process. Whether it is in practice or not remains to be seen. So, on that same note, that this was intended to override other development processes, the application for tentative approval should include a written statement by the landowner setting forth the reasons why a PRD would be in the public interest and would be consistent with the comprehensive plan for the development of the municipality. That is unique. Not a lot of land development and zoning applications emphasize review in conjunction with the comprehensive plan. But as you will see, that's because of the very vast departures that PRDs represent from the underlying zoning ordinance, so vast, in fact, that they are considered to be a map amendment. So when a PRD is tentatively approved and the governing body is reviewing it, there is a lot of emphasis that the courts have started placing on the written decisions that those governing bodies promulgate and the scrutiny that they're applying to these, because it is such a big deal. I mean, it's quasi-judicial, but it's also quasi-legislative in a sense, because those zoning changes are being made by the governing body. So
Again, Alexis, could I interject for a moment
sure.
here? The thing about it being an amendment to the zoning map, I don't think everybody appreciates and understands that, and I think it's important. I think it's central to the entire nature of what a PRD is, to understand that tentative approval, not final approval, but tentative approval of a PRD constitutes a change in the zoning map of the municipality, meaning that there should actually be a change to the map physically made and published. And that if you think about when a municipality normally makes a change to its zoning map, it has to have public hearings. People need to be notified. Anyone who's in that area needs to be notified and have the opportunity to come forward. And that, I think, is often skipped and not considered, and that the officials that are making these decisions are not considering it in the same way as they do when there's a rezoning and they understand that it's kind of a big deal. In the case that we had that we mentioned, when we were first in front of the governing body, and we suggested to them that they needed to take a step back because this development, if tentatively approved, would be a zoning map change. We got a lot of pushback on that notion, even when we were reading it to them right out of the municipality's planning code. It's like they still didn't believe it, and they still would not accept that was true. So if you walk at it, if we were going to give you a few things to walk out of here with, one of them, if you didn't know this already, would be to understand that there's a zoning map change as part of this process.
Yeah, and so, in that same vein, there is this language in the MPC that, when you first start reading the purposes and you start going through chapter 7 of the MPC, which governs PRDs, there's that statement that I read that the application must include a statement of why the PRD would be consistent with the comprehensive plan. But this is also reiterated again in section 703, that every application for a PRD shall be based on and interpreted in relation to the statement of community development objectives and may be related to the comprehensive plan, or shall be based on and interpreted in relation to the statement of legislative findings. So, it just really, this was structured to really be in accordance with the greater development objectives of the municipality that are provided for, whether it be in the comprehensive plan, whether that be in the community development objectives. But normally when you think of a comprehensive plan in light of a zoning or development application, you might think it's just guidance material. It's not binding on the application or on the review process. You can't turn something down because it doesn't comply with the comprehensive plan. In a PRD, that is not the case. The General Assembly was clear that they want you to consider the comprehensive plan or your community development objectives when reviewing a PRD application, and you want to make sure that that is in compliance with those planning tools, because this is ultimately a rezoning of property, or akin to a rezoning of property, because it is that map amendment, which municipalities should actually put into effect on paper on their maps, showing that the area is no longer zoned as the underlying zoning district, but it is zoned as a planned residential development unit. So that, people coming in understand that different procedures, different dimensional requirements are going to apply as opposed to what might apply in the surrounding areas.
And this is the key here, I think, that we've been trying, one of the things we've been trying to emphasize over the years, and it seems like we've gotten through to the Commonwealth Court on this, is that in a typical development, you're used to the old saying, you can't turn it down unless you can cite to some specific objective requirement, that an ordinance provision that the development does not meet. And that's true here also, that with a PRD, that you have, for there to be an issue, it's got to be in the ordinance. But the difference is that the MPC, and we're going to get to this in a minute, specifically, there are specific things that must be in these ordinances, and one of them, as Alexis just said, has to do with the comprehensive plan. And so all of these may be more subjective criteria that normally would not form a basis for denial of a plan are in play in these PRDs by statute. by the MPC saying that they have to be included and that there have to be findings on these topics. And so when you get into what are the proper bases, what has to be looked at, it is a, I would argue, I'm not the Supreme Court, but I would argue that it's a broader scope for the elected officials as to what they can rely on and what they should be looking at in these situations.
Yeah, and I completely agree. In fact, the case that we've been referring to throughout, Gowans versus the Indiana Township Board of Supervisors, there's a quote from there were two Commonwealth Court decisions that came out of that were reported, one in 2019 and one in 2021. The latter has a quote that says, "Given the unique nature of a PRD and its character as a departure from traditional zoning requirements, a board must ensure, prior to granting tentative approval, that the planned PRD does, in fact, meet the specific requirements in a locality's zoning ordinance. This is because a PRD overrides traditional zoning controls and, upon tentative approval, effectively amends the zoning map." And I actually think I can start sharing our PowerPoint now. Let me try to do that.
All right, Jeff just said the chat should work. So if at any time anybody has any questions and they would like to put them there, that's good. And we will do our best to answer those. Alexis is going to put the PowerPoint up in a minute. Next on.
Sorry, Alan, this is Jeff. I just wanted, oh, good. She figured it out. Sorry, Alan.
Yep, we got it. Alexis, I think we're on slide 11.
All right, let me get over there.
Is at least that's where I got us.
So I do want to point out, though, as we're getting there, this map here that does indeed show one of the PRDs being called out on the map is actually one of the municipalities that Alan and I represent out here in Allegheny County, Findlay Township. So, good job to them for actually amending their map to show that a PRD exists in that area. So, all right, slide 11.
Next one. There we go. All right. Nuts, a little bit of the nuts and bolts here just on the process, just because we figure we have to go over the nuts and bolts. So you fill out your application for a tentative approval of a PRD, and the ordinance will say what all has to be in the application, and the MPC tells a municipality a lot of what has to be in there. And I think Alexis mentioned earlier that there needs to be a statement, a narrative that describes essentially why this departure from the underlying zoning would be in the community's best interest. And that should be a real an important factor here, not just some words that are thrown down to check a box. It should be important. And I would suggest that some effort and thought go into that, especially if you're submitting a plan in an area where you think there might be some opposition. So it's required that there be a public hearing. So this is more formal than just a regular land development where you go to the planning commission and then you just have a meeting of the governing body. This requires posting of the property, advertisement in a newspaper if you can find one these days, and notice to people. And again, going back to the map change aspect of this, you can see why that all is important. And again, that was at issue in our case originally too. Improper notice was provided, and the matter was remanded by the court to the municipality, and they still didn't do it right. And then they had to redo it again, and the thing got continued. So you have to have a public hearing, and it's the statute says it's to be concluded within 60 days of the hearing opening. But just like under the regular Article 5 saldo approval process, there can be extensions granted by the applicant.
Sure, and just to jump in there, these hearings are conducted just like any other zoning hearing, board hearing would be, even though this is in front of the governing body, more like a conditional use, like how you would see a conditional use hearing proceed. In fact, the PRD regulations in the MPC cite to Chapter 900, which governs zoning hearing board and other administrative body proceedings. So it specifically says that those should just be conducted in those same ways. And of course, in those regulations is a note that timelines can be extended by agreement of both parties.
Right. And then that's right. And then you get to the end and there has to be a written decision issued. That's okay. We're there. Yeah, so, there has to be a written decision with findings, and I'll let Alexis go over this. But again, when we started out our case, the stage at which we originally got involved was the tentative plan had been approved, and the municipality just issued a letter saying, the thing was approved, and there were no findings of at all. And we took an appeal to court of that, and the judge obviously agreed that there needed to be findings, so he remanded it back to the municipality to really to redo everything, because they had not really done anything correctly in the beginning. But these findings are important, as Alexis will go over.
Yeah, the findings are very important. In fact, in the first Gowans case that came down from the Commonwealth Court, the Commonwealth Court specifically called out the municipality for not making a finding as to each one of these items that were set forth not only in the MPC, but in the municipality's own ordinance. They didn't make 2 of, I think, the 6 required findings, and that would have constituted, I think, a legal error on the part of the municipality, but the board, remedied that by sending it back for further findings and a correction of that. So the first ones, and I'm not going to read these item for item, but the first one is going to be consideration of whether or not the plan is consistent with the comprehensive plan. Again, another reference to the comprehensive plan and the development goals for the municipality. I mean, the General Assembly could not have been more clear. This needs to take into consideration that comp plan. That comp plan does have weight on this development application, and that is very unique in Pennsylvania to see such emphasis on the comp plan. The second finding needs to be, and this is really interesting, the extent to which the development plan departs from zoning and subdivision regulations otherwise applicable to the subject property. And then it goes on to say, including but not limited to density, bulk, and use, which are going to be the big departures that you might see. But this is something that Alan and I have been looking at now for the last 6 years. It's something that we raised to the Commonwealth Court back in, 2020 that they didn't really touch upon. But this language here that's underlined in this slide, otherwise applicable, would refer to the underlying zoning district. So let's say you are developing a PRD in an R3 sort of like multifamily district. You should look at the R3 regulations and criteria of what would be applied to this property if it was not being developed as a planned residential development. And you should include, a consideration in your findings of fact, whether or not those departures that are being proposed in the PRD from the R3 zoning district are in the public interest. The PRD ordinance itself this wouldn't refer to like modifications or waivers that might be being requested, because the PRD ordinance is not otherwise applicable. It is applicable to a PRD application. What is otherwise applicable is the underlying zoning district. So then moving on to the third and fourth findings, another emphasis on the common open space. That is the trade-off that is intended to be made here, is that in one hand, the developer gets increased flexibility and a process that is supposed to be easier and faster. They get to engage in this very developer-friendly process. And in return, the municipality is getting open space, recreation, and it's getting, these preservation of these natural, environmental, and historical resources that might be present in the area. The General Assembly here, I think, really intended to place a great weight upon the type of common open space that's being provided. They want it to be usable. They want it to be able to be used for recreation, preservation, things like that. So we're looking at common open space, the quality of it, how it's going to be maintained, and, that it, is really pertinent and usable by the residents, and that it will be for years to come. So then next is the physical design of the development plan, that it does or doesn't make adequate provision for public services, vehicular and traffic control, and other amenities such as light, air, recreation, and visual enjoyment. So visual enjoyment is in conjunction with, providing that active common open space, that it's, not only visually enjoyable, but also usable in terms of recreation. Which is also called out, the term recreation is, obviously specifically used right here in this subsection 4. Moving on, that the relationship would be beneficial, adverse to the neighborhood in which the PRD is going to be implemented. Again, that's because this is going to be an amendment to the zoning map. You wouldn't place like an island of a C commercial district inside of an R1, surrounded by R1 properties. Otherwise it would be like spot zoning.
Okay, so I want to say something here too. So again, these are sort of like our theories that we keep testing out to see if we're going to be right or not. But so again, the old kind of construct here is that in these development matters, when people who live in the area stand up and complain and say that it's not consistent with the neighborhood, that stuff is almost always rejected as being generalized, not in my backyard type testimony. But here, you have the statute specifically saying that there need to be findings as to the relationship, beneficial or adverse, of the proposed PRD to the neighborhood in which it is proposed to be established. And so if you have 100 people coming to the hearing and unanimously saying it's not going to be, it's going to be adverse to our neighborhood, and they're saying things that make some sense, in my view, a finding by the governing body into the teeth of that, just basically saying, we know better than you what should be in your neighborhood, that might not be upheld. And we're going to find that out pretty soon in the case that we have. Like this, I believe that this provision provides great weight to what, if you have an overwhelming viewpoint of the people that reside in the area.
Yeah, so that's another thing that's unique about these PRDs is, just like Alan said, normally this type of public comment or testimony could be sort of just brushed to the side without very much consideration. Here, the court is going to want you to specifically address, if those comments were made, why the municipality thinks that they might know better than the residents that are living in that neighborhood. And number 6 is just, in the case of a development plan which proposes phased development, the sufficiency of the terms and conditions intended to protect the public interest. So here I think the real consideration was they don't want to start something. A municipality shouldn't start something and then have a phase 1 completed, but phase 2 and 3 are never completed. So what are the assurances that are provided that this plan is going to be fully completed and that the public improvements are going to be fully completed outside of like any sort of bonding or otherwise which might take place here. And I do want to say just before we get into the next slide, I see that Carolyn is on from Environmental Planning and Design, and I would like to, give a shout out to AJ Schwartz, who was our expert in this case, the principal of environmental planning and design here in Pittsburgh. He did a fantastic job, and we are still talking about, the work that he did for us back in 2019 and 2020. So I'll go on to the next slide from there. If Alan wants to start this one out.
Sure. We've been, consistently referring to this throughout. And so, Alexis has, on the slide, she's got a little picture of this original PRD called Fox Chapel Estates that, had a, very long, cul-de-sac, winding back. This property was steeply sloped, and they were going to have to, the part in the back there was really where they were going to be able to get the development. And they did not have they only had one way in and out. PennDOT was not going to allow an access onto Dorseyville Road. Or was it Fox Chapel Road? I can't remember. But in any event,
Fox Chapel
Road. Yeah, they're coming in off of Dorseyville, right? So, what happened in this original case is that the board approved the plan tentatively, and we appealed it. We lost in the Court of Common Pleas, and then we appealed it again. And when we got to Commonwealth Court, this was, I think, if I'm remembering correctly, let's see, this opinion came down. Yeah, this one was filed in June of 19. So we argued this in 2019. So this was pre-pandemic. I did this one in person. So the court here was bothered by the lack of specificity and lack of detail in the decision by the board. It had a lot of paragraphs to it. It had, it was 10 pages or something. There were a lot of words on the page, but it didn't really specifically address what statutorily needed to be addressed, and the specific provisions in their own ordinance. And so we would have preferred at the time if they had simply granted our appeal, but the court felt that they wanted to give the municipality another chance to draft a sufficient decision. And this is another sort of editorial comment. The judge who wrote this opinion, and who wrote both opinions actually, Judge Fasano Cannon, she was an elected official herself before, and also did public sector local government work, and so she is very familiar with writing decisions and how local officials should be looking at these things. And I think that she personally took this case as an opportunity to write about local governments and beefing up their decisions so that when they get to the appellate courts, they can be better reviewed.
Mm-hmm. I agree.
Yeah. So in this case, one of the big issues was that this was just a townhome development, and the ordinance in play here specifically said that the PRD needed to create a variety in the type, design, and arrangement of housing units, and that was an absolute requirement of the ordinance. And the board here thought that because there were different models of townhomes, that fit the variety requirement. But the court ultimately said that variety needed to be all of those things, form, type of housing, not just one type, which was townhomes. All right. So the interesting thing is that even though they made that finding, they didn't grant our appeal at the time. They sent it back because I think the judge wanted to force them to stare at their own mess again. And so that I think they could have just granted our appeal at the time, because there was no way they were going to go back and then dream up a way that 3 different models of townhomes was going to turn into a variety in the type of housing. Yeah. But she gave them another chance.
So we're going on now to the second Gowans case that came down in 2021. And I'm going to try to be really quick because I would like to save some time for questions. So in this second case, we're back at the Commonwealth Court. Shocker. You know, after that revised findings of fact and conclusions of law were issued by the board, we did file another appeal and go back up to the Commonwealth Court 2 years later. So the board issued its revised findings, but the findings were still not supported by evidence, and the board failed to address the testimony of our expert, AJ. These were issues that we raised on appeal, and the Commonwealth Court agreed with honestly everything that we objected to. The Commonwealth Court said that given the unique nature of the PRD, the municipality needed to give more scrutiny to this application, and the decision was not supported by substantial evidence, specifically in that variety type and arrangement. As Alan said, there was no way that they could find, that the board could find, that there was a variety of type of housing in the proposed PRD when it was all townhomes. So they, again, you know, that's where, you know, the first knock was, the first strike suffered by the PRD plan was, but then, you know, we went on to also make an objection to a length of a cul-de-sac and a modification that was granted to that. Specifically, the testimony provided by AJ was critical there, and the Commonwealth Court actually overturned a credibility determination of a governing body, which it never does. Normally, the credibility determination of governing bodies are given almost insurmountable deference. And here, it's credibility determination of our expert and of, in my opinion, the expert that was provided by the applicant was overturned. And actually, the court said that they capriciously disregarded the evidence that we presented. And, you know, it's our opinion that they would have had to have disregarded the evidence that we presented in order to grant an approval. So, you know, going back on to the variety and type of arrangement, that was a legal error and abuse of discretion, and they were reversed. So where does this stand today? It is 2023. Sorry, Alan, go ahead.
Let me say one thing, Alexis, about the cul-de-sac. So I think another lesson to be learned in this case, which can apply to any case, any development, you know, relating to credibility, has to do with what happened here on the cul-de-sac. When this plan was first proposed, the developer was proposing that there be a second entrance out onto Fox Chapel Road. And so this would have been a through street. And that's what the developer wanted. Okay. And that would have been better for the plan itself. But PennDOT was not going to grant that for safety reasons. So, but at the time that this plan was first being proposed, PennDOT had not weighed in yet. And the developer itself told the governing body that they should not approve this unless there was a second entrance because it was an unreasonably long cul-de-sac. Okay. But then months later, after we went to court and the case was sent back, and the first time it was sent back after they messed up procedurally, by then PennDOT had overruled the second entrance. It wasn't going to happen. So then they were back saying, oh, well, we didn't really mean that it was an unreasonably long cul-de-sac. We were just saying that then because we wanted the second entrance, but actually it was fine all along. Okay. Now the municipality bought that. Okay. They agreed with that. But when we got up on appeal, the Commonwealth Court saw that and recognized that there was a credibility problem. And so, because there was really nothing to back up the statement, there was no expert or anything on the other side of this that really said anything. So the point is, when you're presenting these cases, people think they can say whatever they want, but especially when there's a court reporter there taking down what's being said, you have to keep your credibility.
Sure. And so, those statements were made in a hearing, those original statements by the applicant's witness were made in, the beginning. It was actually February 14th, Valentine's Day of 2017. This application was submitted to the municipality in November of 2016. So now it is February of 2023. Where is this today? Well, it is back. You'll see that this is an article in the Trib, published just like last week. We had more hearings. The developer has come back to this municipality requesting tentative approval for a quote unquote new plan. And, we were at those hearings again in opposition. So this has been a long fought battle my entire career, really.
It's sort of like it, but it's sort of like the Who song, meet the old boss, same as meet the new boss, same as the old boss, meet the new plan, same as the old plan. And it was a 3-2 decision and it was approved. And so we're now getting ready to look at whether we're going to talk to our client and discuss whether we're going to take an appeal again.
So here is just some varying comments that were made by two different supervisors on the same board. They both watched the same presentation and they both had different opinions. There's one supervisor who says we can't stop or stifle development when we ensure that it's done in compliance with our ordinance. But on the other side of that, there's a second supervisor that says it just doesn't fit in. If you drive down that road, there's nothing of that magnitude. I don't think the applicant did the job of proving that the environmental impact would be better for a development like this than for a traditional saldo development, which is one of the criteria that needed to be considered. He said that's their burden, and I don't think they carried that burden. So, this just goes to show, how contentious these hearings can be and the different ways that people can view the evidence, because there is a lot of discretion in reviewing PRDs, and that discretion can be, on things such as whether it complies with the comprehensive plan, which is traditionally, like we've reiterated throughout, not thought to be something that could kill an application. But here it is, so that you can look at, the strict, rigid, specific standards, but you can also look at these softer standards regarding, like, how it fits in with the character of the neighborhood here. Both are given equal weight in a PRD application. And this is just a quote reiterating that. And of course, there's, final approval process, but again, really the tentative approval is what matters. Here is the timeline for final approval. Doesn't require a hearing, so you probably won't get another chance to object. It can really only be denied final approval if the development plan that's submitted for final approval varies from the development plan that was granted tentative approval. And even then, the MPC doesn't call it a denial. They say that there can be a refusal to approve, and the developer or landowner is granted an opportunity to cure deficiencies that might be pointed out by the municipality and their refusal to approve the final approval application. Like we said, extremely developer friendly. And then when you're looking at your ordinances that might be in place, or that, you know, you're working for a municipality that wants to provide for a PRD ordinance, you should think about where you want to allow those PRDs in your municipality. Think about the character of the underlying district. Think about how to do things like measure density, bulk. Do you want to, you know, provide for 20% of common open space in every plan? And after they provide for that common open space, is the density calculation made after the common open space is taken out? Or is the common open space included in that calculation for density? Can they include that acreage in their density calculation? You should also think about, you know, things like, what do you want the common open space to look like? Do you want it, you know, to prevent common open space with storm water management facilities? Do you want to provide for specific, you know, criteria that the common open space can't be disturbed at all, or maybe that certain grades and slopes can't be included in the calculation for common open space? Those are some considerations that can be made. And then just here is our contact information.
All right, I want to thank Alan and Alexis for making PRDs much more fun than I have them in my head. For any of the public sector planners that are out there, you know, you started the presentation talking about all the things that the municipality did wrong, and I just had this sinking feeling. There is hope for us. We do some things right occasionally. So, but thanks for working us through that. And I enjoyed getting to know you, and apologize for my informality here, guys, but I'm on the road today. And so, but I'm happy to be here. And so thanks again, Alan. Thanks again, Alexis. If I could figure out how to let Laura in, she's the president of the Southwest section, I would allow her to do what I'm doing now. But thanks everyone for being here. And I think we're at our time. I didn't have any questions. Alan, Alexis, I didn't have any questions. So that must have, I'm going to take it as you did a great job and covered everything everybody could have possibly wanted to know. So thank you. This webinar would also, sure. And this webinar would be available. It's recorded. So if somebody, you know, somebody that wants to get to this, we'll have it available, and then we'll share the PowerPoint to everyone that's registered. So
yes, and I just want to add before we leave, Ryan, feel free to shoot us an email. I see your question in the chat. We can talk offline. That is unusual. And I'm not going to say that it's not doable, but it would be difficult. And, you know, you would have to make sure both municipalities provided for PRD ordinances is the short answer, but I think we have more information we can help you with on that. But to anybody, feel free to shoot us an email with any of your questions. All right. Thank you so much, Jeff.
Thanks, Ryan. Thanks, everyone. Have a great weekend.
You too.